I want to invite Member Robinson to church this Saturday, specifically. Almighty Father, we come before you again, grateful for the opportunity to serve this country. Lord, we ask that as we commence the discussions today, that our deliberations be aligned to your will. Lord, we ask for your protection over each and every member that is here, those that are on their way, and for all of us when we close and leave this house. Lord, for this country, we pray protection, we pray success over every boy and girl, every adult, every resident of this country that we serve. All of these discussions, Lord, we put before you. I ask that you give us the wisdom and the clarity and the determination to make the right decisions, and that you ensure that ultimately the outcome is in the best interests of the people of Jamaica. These things we ask in your kind and precious name. Amen.
Thank you. Thank you, Member Charles. I understand that Dr. Guy has tendered apologies for absence. Okay. And members Malahoo Fort and Member Chuck are on their way. As members know, our chairman also tenders apologies. We hope he will get to us in short order. So without further ado, there are a number of matters that the clerk has indicated to me were outstanding, and the list of those matters. Members will note that the Jamaicans for Justice have delivered a letter. It's dated January 29th, withdrawing their recommendation, one of the recommendations in their submission. I believe all members had a copy of it. And I leave that for you to review. I may say some things about it at a later time today. We also have the document, the Matrix of Fines and Penalties in the 2017 Act for members' review. I think that was requested, yes? And then lastly, our Legislative Council was asked to look at a research matter. So can I ask you just to take the floor now and just to indicate, just remind us of the question and deliver your response.
Thank you, Chair. Pleasant morning, Chair and members. In the minutes of our last meeting on page 6, you'd find where a question was asked by Member Golding Campbell for me as the Legislative Council to check whether the annual report included the number of investigations and the number of complaints received or information submitted to the Commission. You would thereafter find a discussion had by commenced by Member Chuck on page 7, explaining that the report also mentions 6 parliamentarians being investigated. I was asked to look for where in the report refers to the 6 parliamentarians who are being investigated. I started by giving an initial finding based on what I could glean in my short time in the chamber last sitting. And to that, I was able to respond in brief to Member Golding Campbell's question. A more fulsome response is now being provided. In the executive summary of the Integrity Commission annual report, It provides an overview of the Commission's key activities. This information is provided at page 10 to 12 of the 2022 to 2023 report and pages 12 to 15 of the 2023 to 2024 report. The summary covers the following areas: corporate governance, anti-corruption activities, operational activities, financial performance, and their outlook. Under the anti-corruption activities, they have categorized these activities, which includes the information derived or statistics for the Information and Complaints Division and the Investigations Division. In the Information and Complaints Division, the report outlines the total number of complaints and information received or identified for assessment, the number of complaints or information referred to the Director of Investigation for further action, the number of complaints or information closed following assessment, the number of complaints and information kept in view for potential future action, and in the subheading Declarations and Financial Investigations, Procurement and Corruption Investigation, the Commission further provides the number of complaints advanced for investigation, the sources of these complaints, that being whether it was initiated from the Information or Complaints Division or was initiated by the Director of Investigations himself, the number of reports tabled in Parliament, the status of ongoing investigations and their stages, the number of cases closed, the comparison for open investigations, and the number of cases referred to the Director of Corruption Prosecution. With regard to Member Chuck's statement, which is that there are 6 parliamentarians who were being investigated and that was disclosed in the report, I can confirm that that statement is accurate. That can be found in the 2022 to 2023 annual report. What I was looking at in our last meeting was the most recent report that we have, which is 2023 to 2024. So on page 32 of the 2023 to 2024 report, and on page 26 of the 2022 to 2023 report, the Integrity Commission has created a table listing the types of offenses, and the table provides information as to where in the process these offenses are being looked into, whether it is being investigated, whether it is being prosecuted, or whether there is a discharge of liability. The report on those respective pages has listed 6 offenses: failure to file statutory declaration, failure to provide information, providing false information, failure to honor the opportunity to discharge liability, illicit enrichment, or other referral. For each, the report specifies the number of parliamentarians and public officials that are subject to or being contemplated under each offense.
Ms. Simmons, let me cut you a second, because I don't recall the issue at hand being whether or not these matters were reported in the annual report, and members can correct me if my memory is not serving me well. But my recollection is the query really surrounded what was the statutory foundation for making a distinction in the annual report. And as I look at the second schedule, which sets out what ought to be contained in the annual report, right, I don't see anywhere where it mandates authorizes the Commission to make a distinction between one type of declarant and another when it is investigating a matter. And I do not see, in fact, any requirement set out here for that to be done. So that the second schedule speaks to the numbers of investigation, average time take to deal with complaints, description of activities, number of matters. It is asking for basically what you would call the statistical overview of what the Commission has done year on year. And I think that was the concern of Member Chuck, that it was that the two particular categories were being separated and numbers attributed to each, but the second schedule does not actually mandate or require that the Commission do so. So I think that was the gravamen of the concern.
Well, in response to that concern, as stated by you, Chair, Section 36 of the legislation is what is guiding the Integrity Commission in one, providing the report and what is to be contained in it. And it says, Section 36(1) says, the Commission may, at any time, be required by either House of Parliament to investigate a matter relating to an act of corruption and table a report thereon. It continues by stating that the Commission shall not later than 3 months after the end of each financial year or within such longer period as the Parliament may approve, submit to the Parliament an annual report relating generally to the execution of the functions of the Commission during the preceding year, which shall contain the information set out in the schedule, in the second schedule, rather. In the second schedule, I've recognized that there are three key paragraphs that may be contemplated by this committee. Crave your indulgence. Right. So one of the key paragraphs that jumped out to me was paragraph 2, subject to Section 53(3), a general description of matters investigated by the Commission. There is also paragraph 9, such other information as the Commission thinks relevant. However, no details shall be provided by the Commission in relation to any matter under investigation by the Director of Investigation or for which criminal proceedings have been instituted by the Director of Corruption Prosecution. You are correct, Chair, when you have said there is nothing in the legislation that mandates a separation between parliamentarians or public officials when creating their report. I believe then, based on what we have read in the legislation, the section and the schedule, it is really being provided as a matter of form and information rather than what was required by the legislation, explicitly required.
Yeah, I do agree that 2 and 9 would be gives room to make that distinction.
Right.
I think it's unfortunate when you make the distinction, because I think, as has happened, it has sort of thrown a whole class of people into some disrepute. That's my personal view of it. I'm not going to belabor the point, but we've gotten our answer. So thank you very much for that.
You're welcome.
Members, any comments on that? Okay, very well. What is this now? Oh, so we move now to the reading and the confirmation of the minutes. We have two sets of minutes in front of us, January 28th, our last meeting, and the minutes of the meeting for January 9th. Have members had a chance to review? I note that member Senator Scott Motley was absent on the 9th. For both? Okay. All right. Members, have you had a chance to read it? I'm not, you can confirm? Yes, you're quite right. 2025. Or 2024. Is it 2024? Yes. Okay. So is that a motion from Member Robinson for the confirmation of the meeting held on January 9th, 2024? Thank you. Seconded. Member Warmington, thank you very much. January 9th, 2024. Those minutes are confirmed. When were these minutes sent? The 28th?
I'm not sure. I'll have to check.
When were these minutes sent? For last week? For last week? Yesterday? Yeah. That's what I thought. I don't think he's been absent from any meeting of this committee. Oh, I see. Members, let me recommit the minutes just confirmed, please. It's listing Member Warmington as absent. He was not absent. He was, in fact, present. So if we can just make that correction, and I take the minutes as confirmed with that correction, moved by Member Robinson, seconded by Member Warmington. Members would note the minutes of the meeting held last week were delivered yesterday. I'm not sure if members got a chance to read it. I did not. Are any of the members in a position to confirm, or shall we defer this one? We shall defer, yes. I prefer to defer if we have not all properly had a chance to read it. All right, so the minutes of January 28th, 25th will be deferred until the next meeting. Next on our agenda would be matters arising, but as we haven't taken these minutes, the matters arising, I think the clerk's advice as to what we dealt with preliminarily, the advice of the Legislative Council would cover those matters. Am I correct, Mr. Nash?
Oh, no, based on, if it is that we haven't went through it, then we'll just have to, in full sum, then we'll just have to wait. But we would have dealt with two of them already.
Two of them, okay. All right. So we'll look at, if there are any other matters arising from the minutes, we'll take them on the next occasion. All right, very well. Can we now look at the, pick up where we left off, and I believe where we left off was the section 53. Oh, the chair is here. Chair, I'm very happy to relinquish this seat. Thank you so much.
Thank you very much, members, for your patience. And I apologize, we had a slight mishap on my way here. I'm feeling a little more composed now. But I want to thank Member Campbell, Senator Campbell, for so ably deputizing until I got here. And I suspect you've completed most of the preliminaries. And we're now to look at the matrix. Yes?
Okay, that I have another engagement and I will have to leave at 11:45. I do apologize.
If all goes well, we shouldn't detain you that long because I think we have one main item left on the agenda, the matrix to be completed. And we actually had breached halfway in it last week. I recall that we had completed the review of the Permanent Secretary Board's recommendation and that we were now looking at the other recommendations which came from some more of the witnesses that came before us. So with the kind of expedition that characterized the last few meetings without compromising a detailed review, we should be out of here by 12:30. Okay.
Chair, I was actually going to comment on this when I sat just now, but I had indicated to the members, and the members we all received the letter from the Jamaicans for Justice indicating that they were essentially, in my words, withdrawing the position at recommendation 4.1 of their written submission. I am actually trying to find the submission that Jamaicans for Justice had made in my file, and I will find it before the end of this meeting. But suffice it to say, I find the letter a little peculiar. It's a letter withdrawing a position that says, and the position is in relation to the Auditor General's presence as a commissioner. And if I can read, we no longer believe that the Auditor General's presence as a commissioner inherently creates a conflict of interest and recognize that various legislative safeguards exist to address any potential conflicts. Given the critical role of the Auditor General, we now support the office's continued inclusion as a commissioner of the Integrity Commission. We believe this withdrawal will allow the committee to better focus on the remaining recommendations in our submission, which we continue to strongly support. And I appreciate the clarification. It's a withdrawal for me without a clarification. And this is a point that I hold a fairly strong view on. And I would wish to ask the clerk to ask the Jamaicans for Justice if they would indicate, and they can do it by way of letter, the rationale for the withdrawal of their position. I don't see a rationale here. I see we've changed our mind, but I'd love to understand what are these legislative safeguards that they're now confident remove the potential conflict of interest.
Well, member, I think the letter having come to us at this stage, and the chair is only acquainting himself with it at this time, but the matter has already been treated with by the committee. We've passed that discussion. I think there is some referral that in our review after today, we will no doubt take note of. So in our review, we will take note of the letter from the JFJ. But we wouldn't contain ourselves in it at all because that area has already been treated with in the matrix. Yes.
Chairman, their withdrawal doesn't affect this recommendation because this recommendation came from other source, not only from them. So it's still on it. I understand what you're saying, but their withdrawal will not affect this. But I understand what you're saying. Yeah, I do understand you. But I'm saying here it doesn't affect this recommendation itself because they were not the only source that made the recommendation. No, man, I understand what they're saying, but I just want to remind that it's still on.
I would be guided, members. Member Robinson, you will be recognized in a moment. I just wanted to indicate that the fact that one of our witnesses has withdrawn a position would not materially affect the discussions as we move forward. We just note, because theirs is one of many recommendations that came to us on the same matter. So if it is that they have withdrawn their position, we take note of it as we move on to conclude our discussions there. But to bear in mind that that area of discussion has already been completed, and we would only go back in the next few days as we now review the areas that had referrals and where we required more and better details from our technical team that is advising us, as it is not intended to ask any of the witnesses to return to attend to the committee. Member Robinson.
I was just seeking your guidance. You said we had completed deliberation on this particular matter, and I wasn't aware of what the decision was.
No, that's what I'm saying. We're going back. No, I'm sorry. I wish that you didn't understand me to mean that the deliberations on all these matters have been concluded. As I indicated that in our review, we will go back to the areas for which we needed further and better particulars, or that our technical team was to give us guidance. Okay. So can we then move to section 53? And as usual, we have a cantor. So are we going to ask our able Chairman Pro Tem, who is now back in her substantive position, Member Campbell, are you able to carry us through section 53? We had already gone through the permanent secretary's recommendation. We had dealt with that extensively last week. Some members wanted a decision, and I said no, because we had a number of other submissions that we needed to go through on the same matter. So we will then move to the next, which I think the 53, restriction and disclosure of certain matters, yes? And the Permanent Secretary Board had made a fulsome recommendation here. It's on this small, well, we have two, right? This small. Yes, Senator Golden?
Yes. Okay. You want me to go through 53 now? This is the Permanent Secretary's recommendation.
No.
I'm sorry. The other matrix. Okay. So this is the recommendation of the Integrity Commission itself? Okay. No, that's on the larger one. It's at page, are these paginated? Yes, it's a larger matrix. Okay, Chairman, we had done the Integrity Commission one. No. Right. I don't think we had. Yes. Okay. Section 53. And Section 53, members will recall, is what people refer to as the gag clause. The recommendation of the Integrity Commission With respect to Section 53.3, which addresses confidentiality regarding all matters under investigation, it is recommended that the Commission be vested with the authority to comment on the initiation of investigations and on aspects of an ongoing investigation as deemed necessary and appropriate. That is the recommendation of the Integrity Commission. The Jamaicans for Justice recommend that for Section 53, in order to bring credence to Section 6.3b, or to implement best practices as outlined in Section 36 of the SFO Act, then Section 53.3 should be amended or repealed. And the rationale, JFJ believes that Section 53.3 should be amended to be a discretionary clause where the Commission has autonomy to publicly share findings based on the sensitivity of the investigation. This amendment would compare to the Serious Fraud Office Act under Section 36, which is dubbed Secrecy of Certain Information Relating to Serious Fraud Office Business. It instructs that, notwithstanding subsection 1, the Director may disclose such information or authorize any other member of the Serious Fraud Office to disclose such information. A, if the person who disclosed the information to the Serious Fraud Office consents to that disclosure, or B, to the extent that the information is available to the public under any act or which, for the purposes of this act, or in connection with the exercise of powers under this act, or D, for the purposes of any prosecution anywhere, or E, to any person who the Director is satisfied has a proper interest in receiving such information. If this is not a viable option for lawmakers, then JFJ accordingly calls for the subsection, that's 53.3, to be repealed. I am going to go to Jamaica Land's comment on that. We are concerned about 53.1a being used to conceal secret agreements with foreign governments, especially considering that foreign governments can influence our local politicians for their own national interests against ours. This can be done through bribery, coercion, or other means. We recommend, the recommendation they make is that the Section 53.3 be removed, which prevents the Integrity Commission from making public statements on investigations that it's conducting. The Commission should be trusted to decide what it chooses to make public on a case-by-case basis and when it chooses to do so. The Ministry of Finance and the Public Service Financial Investigations Division recommends for Section 53.3, currently the Commission is precluded from commenting on all matters under investigation. It is recommended that the Commission be authorized to comment on investigations from initiation to closure. This section of the Act essentially restricts disclosure on investigations and prevents the Commission from making any announcement that it has commenced an investigation or from providing an update on an investigation until the tabling of a report. The principle of disclosure is an accepted standard for anti-corruption agencies as set out in the United Nations Convention Against Corruption, which Jamaica ratified in 2008. Best FM, the Morning Connection, recommends that in Section 53, restrictions on disclosures be abolished on the ground that it interferes with the independence of the office. Disclosures should be made in the interest of the public and at their own discretion. The same applies to the tabling of reports in Parliament. Pending amendment of the Constitution as regards the powers of the DPP, the Commission should separate the issues of criminal liability from the offences and proceed to exercise its power to impose fines and demerit points so that the non-custodial consequences of breach can be felt. The Norman Manley Law School did not have a comment on that. The PSOJ recommends consideration be given to including some guide as to the threshold of what amounts to injurious to the public interest. And their rationale is that there is no guidance as to what amounts to the restrictions identified, example, relating to matters of a secret or confidential nature and is likely to be injurious to the public interest. So they want that clause, injurious to the public interest, to be, for there to be guidance on what that means. The National Integrity Action recommends, NI's recommendation relates to one of the objects outlined in Section 3 of the Integrity Commission Act, specifically Section 3B, which provides that the Integrity Commission is to enhance public confidence that acts of corruption and impropriety committed by persons exercising public functions will be appropriately investigated and dealt with in a manner which achieves transparency, accountability, and fairness. To achieve this object specifically and the purposes of the Act generally, we submit that Section 53.3, the gag clause, should be deleted and replaced by a formulation which balances transparency and accountability with confidentiality and fairness. And their rationale is that their review of relevant anti-corruption agencies in Canada, the UK, New Zealand in part reveal that there is no gag order on any agency comparable to Jamaica's Integrity Commission. However, in each case, the relevant regulations or law, while providing a distinction, set out criteria to guide the use of this discretion, balancing confidentiality requirements and adequate transparency procedures. The New Zealand example is particularly illustrative and, in NIA's view, provides a good model on the basis of which the Integrity Commission Act, Section 53.3, should be repealed and replaced with a clause providing criteria for balancing transparency, accountability, and fairness, stated as one of the objects in the Integrity Commission Act. So that's the National Integrity Action. And the Jamaica Accountability Meter Portal recommends for Section 53.3. JAMP asks the members of this committee to support the need to amend Section 53.3, to allow for notification that an investigation into a matter, and they have a matter in brackets, has commenced, and not an investigation that names persons. We ask the committee to consider if this section serves to stem or support the fight against corruption. We ask the committee to weigh in if this section supports or denies the Commission of its contractual responsibility to educate the public. JAMP is of the view that all the aforementioned restrictions on disclosure are deleterious to good governance. They're inconsistent with one of the fundamental principles underlying the system of constitutional democracy outlined in Section 2 of the Access to Information Act 2002. Those principles are accountability, transparency, public participation, all of which are significantly impacted by Section 53.3 and Section 56.1. And as such, we recommend the rewording of the sections to repair these concerns. Their rationale is that the current interpretation of Section 53.3 is not consistent with two of the principal objects of the Act. The first concerns Section 3D. The current interpretation of Section 53.3 is also not consistent with another object of the Act located in Section 3B. And that would be the comments. I'm so sorry. Yes, those are the comments on Section 53.3, Chair.
I'm particularly interested in if the committee could ask Jamaicans for Justice to share with us the formulation from the New Zealand Anti-Corruption Agency. I'd like to see what that... Sorry, NIA, sorry, my apologies. If NIA could share the precise formulation from the equivalent anti-corruption agency in New Zealand, which they have indicated balances, fairness with the transparency issue. I'm particularly interested in seeing how that is worded and to see whether it is something that could be used here. I've heard what they have said, but I would just want to see the specific formulation of that particular clause.
I'm sure it was brought up here before,
I think that when they came for the initial submissions, I think it was shared. But I appreciate the call, and while we conclude and go back to our review, we would perhaps find space for a special request. And I want to be careful here because I just made a ruling in relation to the JFF's letter of withdrawal, and that we were not going to require them to explain why they had withdrawn. So I wouldn't want to then, have a member who has rather an organization that has already made a submission to come back to us in the review period. But if it is the will of the committee that that are refreshing, that we either get them to come back or to check to see whether they...
That's not what, in fact, Chairman, if I could just
It's not to get them back. It's rather to research where they had sent that information. Excellent.
In fact, Chairman, in case there was some misunderstanding, that wasn't my ask either. I was simply asking if, just like they have written this letter to indicate to us, if they could just indicate the rationale and the legislative safeguards in another letter to us, not to have another submission, oral submission to the committee, just to provide the clarification by letter. That would be sufficient for me as well.
Well, then that is acceptable, yes. Okay, so we now entertain discussion on the submissions as before us. So our member recall that we had a fulsome discussion on the position of the Permanent Secretary Board just before SG, yes?
Thank you, Chairman. Good morning to everyone. On the same point, it would be good if they could actually send a copy of the legislation, because I'm going online and I can't find the New Zealand legislation. And also sometimes what you may find online may not always be correct. So if they actually have a copy of the act they refer to, if they could also submit it, that would be good.
So Mr. Nash will be so guided in a note to NIA and also JFF. Okay, very well. Just to be correct, so that we have not offended anyone, JFF. JFJ, to be exact, JFJ. Yes.
Chairman, I was asking earlier if anybody has a copy of the JFJ submission here today. I thought I had my full file, but I'm not seeing the JFJ submission. If someone could just let me borrow a copy.
Member, in pursuance of a better position from them, as per
No, separate matter. I was actually looking at this 53. I just want to see a copy, yeah, if I could just... I can continue in the meantime, Chairman.
Yes, please, because it would require a little bit of research, because if you recall, it was a little while hence that the submissions were made, and they were voluminous, in fact. So the Secretary would have to do a bit of research on that for you. But if it is of great moment, we will
No, I can continue.
You can
Is there,
continue.
there's no one who has a copy of the submission, is that it? Okay.
Very
You
well.
don't have one, yours either? Why is everybody missing that one? Okay.
But we will proceed now
Yeah,
with
if Mr. Nash could probably
continuing,
just print one for me, I could take a look at it
continuing to
later.
review Member Campbell.
Section 54.
No, have we concluded on
Oh,
section
I'm so
53?
sorry.
I think last week at the discussion, we had shown some likeness for the submission of the Permanent Secretary Board. So because two members were not here, it might be
Chairman, can I
useful
read that
to
again?
just read that section
Yes.
again.
Yes, okay. So the Permanent Secretaries Board on the same section 53 recommends, it is being recommended that section 7, subsection 8 and section 53, subsection 2 be reviewed in light of the principles of natural justice. The powers afforded the Integrity Commission are too wide-ranging and seem unfettered. The UK Privy Council ruling in December 2021 that the Turks and Caicos Integrity Commission only had the power to demand documents from third parties such as banks after formal investigations have been initiated is of note. The Privy Council in its judgment stated that such powers did not exist in the normal course of the Commission's functions, such as reviewing statutory declarations by public officials. Reference is made to Section 14 of the Prevention of Corruption Act 2021 for Barbados that introduces the concept of disclosure orders. These orders are to be issued by a judge in chambers. When the judge is satisfied that the requirements are fulfilled, the judge makes the order authorizing the investigative officer to give to any person who has information relevant to an investigation notice in writing to answer any question or provide any information or document specified in the document. It is recommended that the IC Act be amended consistent with the ruling of the UK Privy Council in the Turks and Caicos matter to require that information being sought from third-party institutions be done with the consent of the public official and to introduce a requirement for disclosure orders issued by a judge in chambers after careful consideration of the evidence supplied by the IC and only in furtherance of an investigation. Due notice having been served on the public official that an investigation is being pursued. It is noted that Section 711 and 48.5 provide for protection on the grounds of legal professional privilege regarding the disclosure of certain matters. However, both provisions fail to provide protection on the grounds of the right against self-incrimination. That is the Permanent Secretary's recommendation. And Chairman, I have a question just coming off of this. The right against self-incrimination is constitutional in nature, and my question is posed to the SG. Would it matter that those provisions don't cover it? I mean, at the end of the day, if it's a constitutional right, it's a constitutional right, is it not? No?
Chairman.
Sorry, Chair, I'm not prepared to answer today. I'm sorry. So at the next meeting we can answer.
The New Zealand position. So if you
Right, but we just wanted to dispose of Member Campbell's request.
That's fine. She'll talk to us at the next meeting. That's fine.
Yes, because I was not at the meeting last week, and one of the things that I would like to be advised of is whether or not the provision which was being ruled on by the Privy Council is similar to the provision which we have in our legislation. Because it was heavily cited by the Permanent Secretaries Board.
Your mic.
I don't recall at all because I wasn't
They didn't
here.
present in person.
I wasn't here and the meetings,
No,
the
no,
minutes
not
were
last
tabled
week,
late.
you know. I'm talking about
Oh,
at
you
the
mean when
time
they did?
of the, yes. But I suspect that submission was guided by the outcome of a Privy Council ruling.
I sent the news, sent it, NIA submission.
I'm just not clear what the nature of the law that the Privy Council was actually ruling on. I just wanted to know whether it was in fact a similar clause, just to understand exactly where the permanent secretaries are coming from.
My
We'll make
recollection,
note of that.
Chairman, just to assist, that case from the Turks and Caicos, to the best of my recollection, which I read some time ago, was saying that the Integrity Commission should not be asking for information from various institutions without the permission of the persons. In other words, the idea that you are seeking public officials' data, be it from the bank, be it from the Registrar of Companies, or from the Titles Office, it should not be done without the consent and knowledge of the public official. Is that my understanding, SG?
Yes, but to speak to whether the provisions, so their act or our act is very similar to the act in the Turks and Caicos, but I can't speak to the actual provisions. I'd have to go back, which is why I was asking if we could just respond and deal with this issue at the next meeting. Because I can't recall that specific provision in theirs to see if it is identical or similar to ours. But generally, their act is very similar to our act, which is why I had actually referred to that case when we were looking at another provision in our review. So there are a lot of similarities. I just can't speak to that very specific one. And just through you, Chair, to Senator Golding Campbell, Mr. Foreman had a copy of the JFD submission, so we've asked for it to be copied.
Thank you.
Right, I have the NIA submission, which included the New Zealand position, which, if I sent it to you, but if I might read it so that we can discuss it. In it, this is number 10, Julian, I sent it to you. In New Zealand, Serious Fraud Office, SFO, is, quote, the lead law enforcement agency for investigating and prosecuting serious financial making a public statement so as to enhance but not compromise the investigation. The factors on the basis of which a SFO decides whether to issue a public statement include, firstly, public interest; secondly, reputational damage or harm to individuals or businesses under investigation; thirdly, level of detail required to ensure high levels of accuracy in reporting; fourth, other information which is in the public arena, for example, confirmation of a referral to the SFO by another agency, and investigations into the relevant matter by other organizations. Taking the above into account, the website of the SFO identifies a number of entities that the SFO is investigating. Information on cases is published in categories of open, investigation, prosecution, and closed. Please note that in some instances, the identification of the entities accompanied by this request. Please contact the SFO if you have information that may be relevant to this investigation by emailing now. In the interest of completeness, this is what NIA is. We should note, quote, the SFO will not generally comment on an investigation until the point where charges, if any, are filed. Question why? A statement that the SFO is investigating a person or entity can cause damage which cannot be remedied even where it is later decided there is insufficient evidence to commence proceedings. Now, that latter part, Chairman, is what we have stuck by. we said don't comment on an investigation until you're almost at the point where you're going to make a charge. Because once you charge, or you say it has been referred, to the director or to the DPP for a charge to be laid. And so, Chairman, I'm not too sure that we need to modify Section 53 at all. Because what we should, and my position is Section 53 was put there to avoid reputational damage to public officials, so that if you start commenting on an investigation, from you say that a person, or for that matter, a municipal corporation is being investigated, it raises so many reputational damage. You see, Chairman, where it is reported that, say, a municipal corporation is being investigated. Everybody starts to say, I wonder who do this, wonder who do that. It's the same, Chairman, I would say, what should be noted, the commissioners in their annual report should also be very careful about who they say or what body they say are being investigated. Because if they come out with a report that they're investigating, say, 2 permanent secretaries, as I mentioned last week, it creates reputational damage to that body, say, of permanent secretaries. I'm not saying they've done so. But when you do that, you create a problem of speculation, and that is why I've repeatedly said Section 53 was put there, and I was a part of that Joint Select Committee to avoid reputational damage to public officials, which at the end of the day, it is as the New Zealand position say, you can't remedy it. Don't care how you say that, you withdraw the speculation. So, Chairman, as far as I'm concerned, even though most of the submissions are saying the so-called gag clause should be removed, it is there to avoid reputational damage, and my position is that it should remain as is.
I mean, I heard what Member Chuck read on the New Zealand guidelines. I really wanted to hear the specific legislation, because what he read, in my view, still leaves a lot of discretion open to the particular anti-corruption body to determine whether it comments or not. Now, when it said, the critical thing that Member Chuck said from the New Zealand legislation was it wouldn't comment until it is in a position to recommend. In our scenario, a recommendation has to go to the Director of Corruption Prosecution, who can either agree or disagree. Now, if you follow that principle, you would maintain the status quo, as is right now, because that's in essence what exists now, which is that a report comes to the Parliament, is tabled, a recommendation has been made, and an indication is provided as to whether that recommendation has been either adopted or rejected. But as I said, I still want to, Member Chuck sent it to me, I'd like to see the specific wording of the legislation. But I think, like Member Chuck, I do have the concerns about the inability to repair damage once an announcement is made, and that great care must be taken in how we treat with this particular clause. I think that the challenge is and I know investigations take a long time, particularly related to financial matters. I think the length of time in tabling reports, is what gives rise to the speculation and the anxiety. I'm not with Member Chuck on the issue of the annual report of the Integrity Commission. I'm not offended by the particular the descriptions. I'm not offended by that, because I do believe as part of their own accountability in terms of an agency which receives a very large budget, it is important to know who they are investigating and where they are with those investigations. So it doesn't bother me that particular categories are highlighted. I think the reality is that in our society, members of parliament, just by virtue of who we are, get more scrutiny than everybody else. So in the table, it says permanent secretaries, public officials, other people, but everybody focuses on the members of parliament. I can't blame them for that. That's the nature of the society. I mean, I have been critical of the Integrity Commission in the past by saying, you know, why is it taking, you're getting $5 billion a year, or what, I don't know what the figure is, but why is it taking you so long to investigate critical matters? So I wouldn't change that because it's important for them to account on their work. I think what the public wants to see, having seen whether it is 6 officials on the investigation, they would want to see timely publication of timely tabling of those reports in Parliament, so it reduces the speculation and the anxiety that might exist in particular groupings that are highlighted.
Any other comment from members on this? Just to indicate for guidance of our technical team that will have to do the drafting afterwards, is that we usually make decisions as to whether we amend or change or recommend a change on the basis of a sense from members as to whether the change is necessary. And looking at this particular section 53, going through the recommendations as per the various witnesses that have submitted to us, and listening also to the discussions, I am to be guided as to whether we have reached a level of agreeing to change or not to change this section 53. I await a response from the SC in relation to the issue on the constitutional implications of the change as suggested by one of the witnesses, and indeed in response to the question that Member Campbell asked of her. So I await that, and so hopefully after we finish this matrix and we do our review, we can formulate a final position on that.
I must state that I'm still to be convinced that there needs to be any change to Section 53. I'm not convinced we need to change anything there. Yeah, I'm not convinced it needs to be amended or changed.
We hear you well, member, and as I said, we are only being guided by one final factor, that of the SC's response in relation to the constitutionality of any change. Yes.
Let me say, unlike Member Warmington, I am convinced we are not to change. He's put it negatively. And the reason why I'm saying so, Chairman, since 2017, when this act was put in place, I know of many cases, and in fact there are cases, where the Integrity Commission has taken years to submit its report. Suppose, Chairman, that the persons, or it is known to the public, let's say, use an example, that the Minister of Justice is being investigated. Immediately, there would be a call for the Minister of Justice to step aside until the investigation is completed. And then 2 years later, it turns out it was a mistake, it should not have been done. Think of the reputational damage that would have occurred to the Minister of Justice or any public official, Chairman. And that is why I repeatedly said, you don't have to report that you're investigating. Investigate and then report. And that is the basis of Section 53, Chairman. Because if you start saying you're investigating 2 councils in this municipal corporation, you're going to immediately you're going to say those two councils must identify themselves and withdraw. So that one has to be very careful, and that is what has happened across the world, Chairman. You don't, especially in matters like this, identify a body or a set of public officials and cast speculative or speculations as to who they are and what the investigation is all about. As I've been told, the IC has been everything they've asked for. In fact, if you look at the budget, they're getting about $2 billion, Chairman. And every opportunity should be given to them to do their work. I must tell you, in the last few months, I've seen that they have started to put advertisement in the papers, asking for persons if they know of anyone engaged in corruption, bribery, and so on. That, Chairman, is what they should be doing. They should be begging and urging public officials, using the access to information, using the Protective Disclosure Act to ensure that where Jamaicans, anyone knows of corruption, that it is exposed and brought to their attention. So, Chairman, I've said it repeatedly. We want the IC to succeed, but it has to proceed in a manner that is open, transparent, but protect the reputation of persons who go into public life and may, are there because they want to make a contribution, and without the fear that you could have some malicious allegations being put against them and their reputation would be totally destroyed. So I would say, Chairman, that as far as I've seen and having seen how the IC have operated over the last 5 to 7 years, I have no doubt that Section 53 should remain as is. And if you ask me, some of what they put in their annual report, it could be even greater circumscribed that they can say it in their annual report that they are carrying out investigation, 20, 50 investigation of various public officials without identifying any category, Chairman. Because when you identify categories, it creates too much speculation.
I think that we've heard quite a bit on this one. We are driven by the positions that members have put forward. We get a sense that members are inclined to consider retention of a clause, providing, of course, all the other areas that are to be given attention is in fact done. So the member from member Julian Robinson made a point that he has a parting of ways with you in terms of the report itself and whether categories should be omitted. And I think that the 53 should not prevent categories in general from being, but definitely the argument of ensuring that there is complete investigation before individuals or organizations or institutions are named is critical. And so to the extent that 53 protects that, we are inclined to support 53.
I thought the matter was going to be deferred until we had a full discussion and we had all the information. But before I go, I just want to make one remark. I've not seen any of the submissions which suggest that we should retain 53. All the submissions which I've heard ask for some changes to be made, but basically they are against retaining it in the form, this present form. And my concern is that when the Joint Select Committee considers the submissions, how they treat with them. Because it seems to me as though we are we are using our own views to determine the approach. And I'm a little bit concerned about it. Now, let me say this. I am wrestling with it. I don't like it personally, but I am very unclear as to whether it is my personal opinion that should drive an amendment to legislation, or it is that having asked for public comment, for people to participate in a process, that we should at least take it into account to arrive at some kind of decision. And I frankly want to await seeing the New Zealand legislation to see if there's some compromise which we can arrive at to protect the persons and to satisfy the public's demand for accountability. One of the things that concerns me is that it is the parliamentarians who consider the provision to be most oppressive, because although I agree with you that saying 28 public officials is a broad category, that is Minister Chuck's comment, I agree with him, I still find that the protest is only coming from the parliamentarians. And I just want, Chair, as I take my leave, because I should have left 5 minutes ago, that we contemplate what is supposed to guide the amendment. What is supposed to guide the amendment?
Okay. The committee takes note. Bear in mind that we have been meeting for nearly 2 years.
Not really.
Having a year and a half, having met with and had witnesses covering about 10 to 15 different categories. And we have managed to distill from all of that the essence of their recommendations, and that constitutes this matrix. So it is not a personal opinion.
No, but we're going
and I, as chair, would take note, very careful note of that it's not about a personal opinion. And if you notice that in all of my comments, it has been about consensus and what the committee is saying. In addition, I would just refer to the fact that several referrals have been made to our technical teams for their guidance before decisions are made finally. Yes, so we're not there yet. What I indicated a while ago was the feeling and what I sense from the discussions around. And recall that I indicated that a final decision on this particular section will be taken after the SC has given. So
Chairman?
Take note of that, and then your comments will be faithful in terms of the chair's position.
Chairman?
Member Campbell.
I too am very interested in seeing the New Zealand provisions. And I would also like to read the case, the Turks and Caicos case as well. If the clerk could provide us with copies of that, I'd be grateful. Furthermore, Chair, I know the comments that have been sent in to us, and I take note. We have comments from the Ministry of Finance, we have comments from the PSOJ, and we have comments from 1, 2, 3, 4 civil society groups, JFJ, LANS, JAMP, NIA. We have comments from BESS FM, and we have comments from the Permanent Secretaries Board. And I want to make the point, Chair, while the submissions from these groups are well appreciated, as a legislator and sitting in the chair having to deliberate and contribute to the decision of the committee, I am still very conscious that these groups who have submitted to the committee do not represent all 2.8 million people in the country. And in fact, they don't even necessarily represent the officials who are the public officials, and I can't remember is it 100,000? I might be wrong on the number, who are impacted by the provisions of this act and the decisions that we make in this committee and later in the Houses of Parliament. So I want to be very careful that while I hold my own personal view, one, I don't want to insert my personal view. It must be guided by best practice, etc. But I also want to say, Chair, that the submissions are matters to persuade us in a particular direction, but that we still have an obligation to consider wholly the matters before us, so that we're not substituting for our personal view, which is a danger we wish to guard against, the views of another particular entity without a broad consideration of the act, the intent of the act, the international best practice in terms of anti-corruption practices and agencies in jurisdictions that we consider worthy of emulating, and also that we read the legislation and we note the opining of the courts, the relevant courts to our jurisdiction. So I don't have my own personal view was that I was not open at a point to the removal of Section 53(3). I think I have said so publicly before. But I must say that when you look at the comments of the bodies who have submitted to us, and when I consider the history of how, certainly in my time of looking at it, investigations have been conducted, comments have been made in the public domain, etc. I have to recognize that a big part of the problem that we are grappling with is the fact that there has been, to some extent, an abuse of the powers of commentary and disclosure in the past, which have caused officials and public servants to be wary of the power to comment. Now, we are public servants, but we are the public servants who get to decide what this law says. So we have to be very cognizant of that responsibility. And we can't, although the temptation is great, succumb to our fear, but at the same time, we have to be guided by what the facts are in terms of how the Integrity Commission has conducted itself. I think those things are relevant. And so I'm not going to say anything further in relation to that. I don't want to get into impugning them. I'm simply saying that the concerns of the Permanent Secretaries Board expressed here are not concerns that have just been pulled out of a rabbit's hat, like a rabbit out of a hat. They speak to the experiences that public servants have had when disclosures have been made, and as Member Chuck talked about, the matters went no further. So that said, Chair, I welcome the case and the legislation that we're to look at from New Zealand. But I want to just remind the committee, as I had to reread it to myself, the Integrity Commission and the principal objects of this act are at Section 3 to further encourage and promote propriety and integrity among persons exercising public functions, to promote and strengthen measures for the prevention, detection, investigation, and prosecution of acts of corruption, to ensure government contracts are awarded, varied, renewed, or terminated impartially on merit and in a financially prudent manner. And D is to enhance public confidence that acts of corruption and impropriety committed by persons exercising public functions will be appropriately investigated and dealt with in a manner which achieves transparency, accountability, and fairness. So one of the objects of this act is to enhance public confidence that in fact the Integrity Commission is doing its work and doing its work in a manner which achieves transparency, accountability, and fairness. What we're grappling with is that we feel that there's been some unfairness in the past, and how do we further the purposes of the Act while taking into consideration the need for that fairness, and how do we enhance public confidence? That's I'm trying to articulate what I think we're all rolling around in our heads. But I will say further, Chair, that the Integrity Commission, well, I sort of almost forgot my point a while ago. The question that I have to ask, based on the submissions that have been given, and because the point I'm not clear on, how does the autonomy or authority to comment and disclose on an investigation further the objects of the Act? There's an investigation that the Integrity Commission is going to do on a public official, and the Integrity Commission wishes to make a public statement about what? I do not understand what the nature of that public statement could be that that would further or enhance public confidence. If it is just the fact of an investigation, if the Integrity Commission wants to be able to say, today we launch an investigation into a public official for the following, looking at breach of the following provisions of the Act. That's very general. It tells you that there's an investigation going on and the nature of the crime that the Commission is looking into. It says nothing more. I don't think it impugns character in that way. I don't think there's a risk of reputational damage in that regard. But that's something we can legislate. We can create a provision to allow for that kind of general comment without there being anything that would run the risk of reputational damage. And in fact, one of the submissions from JAMP speaks to them being permitted to say a matter is being investigated. Again, and I'm going to go back and look at the Integrity Commission submissions on this issue. What exactly is it they wish to say? I really don't understand. If you have an investigation to do your investigation. I don't understand the need for public commentary in the matter. I suspect the argument is going to be, but when the public knows that it's happening, the public gains confidence. And I respectfully disagree with that. When the public knows that you have investigated a matter and you have completed your investigation and it has been thoroughly and well done, and you have referred this matter for prosecution, and the Director of Corruption Prosecution says, yes, your evidence is there, your findings are sound, this is a matter to be prosecuted. That is what, in my view, enhances public confidence. And you take that matter to court, and a public official who has breached the Integrity Commission Act is charged and convicted. That is what enhances public confidence. My fear is that a whole lot of announcements, I'm going to wrap up now, Chair, a whole lot of announcements about investigation that do not lead to completed investigations that can be taken to trial don't lead us anywhere good. So I am concerned. I'm open. I will declare I'm open to being guided. I have some more reading to do. But those are some of the considerations that attend in my mind.
Okay. All right. So I think we've really spent, I would say, a lot of time on this, although I recognize how important it is, absolutely, and it is perhaps one of the really heavy sticking points in this entire review of the act that we've been doing. But I do not wish for it to contain the committee beyond what is a reasonable time, in fairness. So I will allow for 2 other interventions. We do have a time constraint for today, and I really wanted to have gone beyond just one section today, since it is my intention to absolutely to complete the matrix. So go ahead.
Right, if you could just allow...
Just 2 comments. I've circulated the case from the Turks and Caicos to colleagues who are here. And Chairman, I've sent it to you. Could give it to the Secretary to circulate it to the other members. That is the Privy Council case from the Turks and Caicos, which we mentioned. And I also send the NIA, submission.
Which we have here.
All right, I circulated it also. But I think what Member Golin, Shireen,
Member
Golin said is important. Let us face it, Mr. Chairman.
And she said it very well.
Yes, no, and it's important.
Just to
because
remind you, she said it very well.
Right. So, Member Golin, let me make the point. You see, what you have said it very clearly. To be frank with you, to the best of my knowledge, I see overseas many contracts. But suppose they even mention that they were investigated. Now, from the overseas, Chairman, when I know of a big contract the Ministry of Justice was involved with. And the IC was there on a regular basis. I said, no problem. They came, they visited, the contract was completed. To be frank with you, the Court of Appeal, renovation of the Court of Appeal. Court of Appeal is a first-class court now, contract properly executed. But suppose, Chairman, it was reported that the IC have sent their people down to look at how the contract has been performed in the Court of Appeal. Then the impression might be given that something has gone wrong. When, as you know, Chairman, even our CDF, the IC examined several aspects of the Constituency Development Fund, and they report on it regularly, annually, you know. So what we're saying, Chairman, just to report that IC is investigating, even if they're just overseeing, cast doubt and speculation, and that is why Section 53 is so important, why we should maintain it, that you don't report an investigation until, as the New Zealand statute, the fraud says, until you're at a position where you can make a charge.
Indeed. Very well. Member Robbins.
Chairman, I'm shifting gears a little bit. There's another clause, and I can't remember the exact number, which prohibits the Integrity Commission from publishing the contracts that the government of Jamaica has entered into with various different companies. I don't remember. I don't know if we have passed that in the.
It's in this same 53.
You sure it's 53?
Well,
I think it's another one.
Comments have been made and submissions made in relation to that. Particularly if you notice I think the Public Service, Ministry of Finance and Public Service made a comment in that regard.
I don't think it's 53.3. I think it's another section. Which one? 36, yeah. Have we passed that? Because I feel very strongly...
Yeah, we passed that long ago.
Long ago?
Yes.
And what...
But in fairness, another comment has been made here with regards to
Is which one?
contracts and provisions that were reported by.
The reason I'm raising it, I mean, on this score, I support the Integrity Commission's recommendation, and I don't know if it's 36. I'm told it's 36. If that is the clause that prevents them from routinely doing a quarterly publication of contracts that have been entered into with the government of Jamaica with public funds.
We'll go back when we do the review.
No, they have said it doesn't.
Yes.
Member Chuck, they came here in front of us and said that the clause prevents them. You'll recall that under what used to be the Contractor General's office, he did a publication. They said that they can't do it because of, I think it's clause 36.
Recall that we are finishing the matrix and then reverting to the areas for which there is need for further and better particulars. Allow us to do that, and we will come back to 36, and at that time, we certainly will allow your comments and your guidance as to what the final ruling on 36 would be. Right, so we move to 54.
CPC, you're saying that the point Member Robinson was raising is section 36?
No, 36 allows an interim report.
Okay.
Now that he's clarified, I think it may be clause 56.
56?
Yes, yes.
Okay. Okay,
Where they are
thank
to
you. I just
regard
wanted
and
to
deal
be
with
clear on
secret
the
and
reference.
confidential all declarations, government contracts, prescribed licenses,
Okay.
and other matters, yes.
Thank you very much, because I was saying 36 wasn't, okay. So, Chairman, you want me to go now to section
54.
54. And this, Chairman, is the, and I'm going to be looking at both the Permanent Secretary's comment on this as well as the other comments from other other entities. Okay, and there was none from them. All right. So on two separate matrices, sorry.
There's not much on 54.
So 54, Chairman, does not, I don't have any comments from any of the groups who made submissions, except for Member Warmington, whose recommendation was that section 54(1) be amended as follows, that on completion of an investigation, the Director of Investigation shall prepare and submit to the Commission through the Executive Director a report of his findings and recommendations together with the ruling of the DPP, if any. The above amendment is not only appropriate but necessary based on a recent issue involving the PM. The rationale for Section 54 states that whereupon the completion of an investigation, the Director of Investigation is satisfied that there are reasonable grounds from suspecting that there is a breach of the Act or an act of corruption, Section 54(1) authorizes the Director of Investigation to submit his findings to the Commission through the Executive Director. The Director of Investigation is also required to submit the findings to the Director of Corruption Prevention, who may take such action as may be deemed appropriate.
Okay.
Chairman, can I just say in relation to this one, because I certainly recall last year, February, almost around the same time, with two reports that were tabled within 48 hours of each other. The first, which caused a great deal of concern and damage, and the second, which then removed. Yes, well, it's more than clarified. It said there was nothing to prosecute. At the time, and since that time, to my knowledge, I have not heard anything from the Integrity Commission in terms of how it handled the tabling of those two reports. I have not heard anything. I don't know if they have made a statement about it, but my recollection is what I did heard was almost a doubling down on the correctness of how they had managed that process. I think this amendment that Member Warmington is asking us to consider is really in response to that sort of gray area. And the question is, when the Director of Investigation completes his investigation, and let me remind us all that an investigation report is a report on findings of fact. It is not an analysis of law or whether or not the public official that is the subject of the report should be prosecuted. That function belongs to the Director of Corruption Prosecution. So in the scenario of last February, my recollection is that the Director of Investigation's report was completed and delivered to the Director of Corruption Prosecution for her consideration. And she considered it and prepared a report. Now,
that was available.
Prepared a ruling, I'm sorry, thank you. So the question is, Member Warmington is asking us to amend to say that when the Director of Investigation submits his report to the Commission, that he does so together with the ruling of the DPP, if there is a ruling. Now, the Director of Investigation passes his report. I'm not so clear on what compels him to pass his report to the Director of Corruption Prosecution for her consideration before he sends his investigation report to his commission. I would be guided if there is a provision in the Act that says how that is supposed to happen. But if there isn't, it would seem to me it's a matter of their determination of a work process, and that the Director of Investigation could very well send his report to the Commission, and the Commission could table that report. Nothing prevents them from doing that before it's referred to the Director of Corruption Prosecution, in which case you have the same type of potential for reputational damage if what you have in the report is material that the Director of Corruption Prosecution says does not rise to the level of a criminal offense. So I would support this amendment to include the Director of Corruption Prosecution's ruling, but I would go further to ask us to consider whether or not we need to, there should be some mandate in the Act that if the investigation report is completed, it must go without delay to the Director of Corruption Prosecution, and once her ruling is completed, then that is the time for tabling of the report, so that we don't have a scenario where you can table a report and cause the kind of damage that we are wary of, but that you can have an investigation completed, properly considered, and if it is to be prosecuted, then you have a clear-cut case to take to the courts.
If you look at Section 3, subsection A, subparagraph 2, the Director of Investigation can't, of himself, submit a report to the Director of Corruption Prosecution. It has to be done through the Commission. Okay. So we need to look at that.
Chairman, I think what Member Golden has said, to be fair, that is how the IC seem to be operating, where the Director of Investigation has completed his investigation. It appears, it goes to the Commission, and if he recommends that it should go to the Director of corruption proceeding, it actually gets there. So to the best of my knowledge, when a report is tabled in Parliament, even if the Director of Investigation has recommended that it should be a ruling is needed from the Director of Corruption Proceeding, that usually happen at the same time. What was very unfortunate is that last February around this time, that even though the Director of Corruption Proceedings ruling was available, it was not released at the same time as the Director of Investigation's report. You recall that, Chairman? And that is what created the problem, and that is why Member Warmington's position is, if it is available, it should be published at the same time. And in fact, before you publish the Director of Investigation, you should at least have knowledge of the ruling, positive or negative, of the DPP or the Director of Corruption Proceedings. So Member Warmington's position here is should be taken into consideration so that you don't have a lapse, as Member Golden is pointing out, where in fact the ruling might in fact be negative, but it is out there that it has been sent for a ruling. So that it should be taken into consideration.
I think there are two issues, and you want to, at all times, remove discretion. So the Director of Investigation sends a report to the commissioners, who would then refer it to the DCP. The question is that obligatory, or is that at the discretion of the commission? That's important, because you have to resolve that particular issue. And then the second issue relates to the timing, that there should be simultaneous tabling once the DCP has made a ruling. But I would want clarity as to whether it is obligatory on the part of the commission, once it's in possession of a completed report from Director of Investigation, to refer to the DCP before it acts any further in tabling it. So I'd ask the council if you could guide us. Huh? Yes, but I don't want that procedure to be discretionary, because that is how we had the problem before. I want that to be firmly established in the law. And the reality is, I think the Integrity Commission has operated in a kind of siloed environment, I think, based on how the law was structured at the time, because it was an amalgamation of 3 different entities. But that silo can create its own problems. And I think in reviewing it, we must ensure that the level of communication, it may simply be a workflow issue, but it should be institutionalized, that it is something that must be done once they're in receipt of the report. So I would be guided if you could indicate so.
Because of the way the provision is drafted now, that is not absolutely clear. So I'm thinking that we may have to do some tweaking to the same 54 to ensure. Yes.
Member Warmington? Go ahead. You're going on?
No.
Oh, I thought, okay. Chair, I have a further point to add on section 54, section 54.1. And this, again, is arising in my mind because of the experience I have had reading reports. And 54.1 says the Director of Investigation shall prepare and submit to the Commission through the Executive Director a report of his findings and recommendations. And I wonder if any of the team could opine on what was the rationale in including recommendations there, because the Director of Investigations who submits a report of his findings, what would he be recommending? I mean, all he could do is to refer the report to the Commission, who could then refer it to the DCP for a ruling as to whether or not there is a prosecutable offense there. If his recommendations are about further referrals of the report, which I believe has also been an issue that has arisen in matters, it would seem to me that those recommendations would be contrary to Section 7 of this very same act. And so we would need to reconcile what we mean by the Director of Investigation's recommendations. If he's making findings of fact, and the only thing you can do with these findings of fact is to determine whether or not the person who is investigated has breached the act and should be prosecuted, then it's not for him to make that recommendation. It is for the Director of Corruption Prosecution. I would want some clarity in exactly what we mean by this. I'm not sure.
Right. So I see.
Sorry, no. Just to speak about the reason the provision is worded that way, we would have to go back through our files to see, and so we could report on that at the next meeting to see what were the instructions given and why. I'm hoping that we'll see something at the Joint Select Committee stage. I don't know what I'll find on the file.
Okay. So just...
Sorry, but I actually had my mic on before because I realized that there was a exchange where Mrs. Seeley Brown was saying a provision would need to be tweaked. But we don't have an instructing ministry, so the Joint Select Committee members are basically the ones now giving full instructions. So if something is to be tweaked, you really need to know, say, as a matter of record, what you want tweaked with the law. Normally what would happen is after the Joint Select, the instructing ministry would then send instructions. We don't have that here. Remember, this is a commission of parliament, so we don't have an instructing ministry. So I'm just asking that when the recommendations are made, we may need to get, Mrs. Seeley Brown will need to get very clear instructions. And that's why from time to time we'll interrupt to ask, what was the decision taken and so on.
Could allow me? I know, but just to be clear, what I would like is that there'd be no discretion once the Director of Investigation completes a report that is sent to the Commission, that the law provides that the Commission must submit that to the Director of Corruption Prosecution for a ruling. And once a ruling is provided, that both reports be tabled simultaneously in the Parliament.
Yes. So that's what the amendment would give effect to, essentially. So we can accept that. 55, can we?
And I agree with Member Robinson. I don't want the discretion either, but I wonder if we could get some clarity just by writing to the IC for an explanation on process, because if you think about it, if the Director of Investigations is getting 200 complaints and he's investigating, if he's doing 200 investigations, not that he's getting 200 complaints, but if he's doing 200 investigations for argument's sake, and he has to complete a report on all 200, in other words, he does not get to start an investigation and not complete a report. Even if he truncates an investigation, I would imagine he is duty bound to produce a report to the Commission to say why he has truncated, why he has ceased his efforts, or that he has completed the investigation and this is a full report on the matter. So if we are creating a provision where we are removing the discretion and we're saying the Commission must send every report sent to them to the Director of Corruption Prosecution, we may very well be inundating that office unnecessarily, because there are going to be many of those reports that don't need the Director of Corruption Prosecution to see them to recognize that they're not matters that you can go any further with. So I'm raising this. It would be for CPC to determine how she puts that into the language. Right. And it would also, I think, require from us an understanding of what the Commission's process is in that regard as of now.
Yeah.
Just member Golden, remember we still have 54.2, which says that if he starts an investigation and there are insufficient grounds for continuing, he terminates and he reports his findings. Of course, those I wouldn't go to the Director of Corruption Prosecution. I think what would go are the ones that he thinks, based on Section 54.3b, an act of corruption has been committed, and the Director of Corruption, the Director of Investigation will then recommend that those matters be referred to the Director of Corruption Prosecution. So I'm thinking it's not everything Member Robinson is thinking should go, but only the ones where it rises to a particular level, yes, because it's already covered on the 2 that if it's frivolous or vexatious or if there's insufficient information, he ends it, but then he still reports those findings to the Commission.
Correct.
Okay, so under 54.3 would be the ones that go to the DCP. Okay.
Very well. Okay, so so we take that one and we move to 55.
Okay. So 55, Mr. Chairman, is the...
And just to bear in mind, now we are at 12:30. Parliament has to prepare itself physically for the session. That's what I thought, that we would have finished them all today, but...
no, we have more than that.
But it is clear that members have further and deeper thoughts.
All right, let's try, 55, Chairman. The Norman Manley Law School proposed that Section 55 should be amended to include a definition for privilege on the rationale that they're of the view that the Act could benefit from a definition of privilege. This is so especially if the recommended amendment to Section 48(6) is accepted. Yeah. Section 55(4) treats information provided orally or otherwise in any investigation or proceedings before the Commission by any person as privileged, as if they were produced in proceedings in a court of law. I'm sure is what that's going to say. The Act expressly preserves the right of persons to assert legal professional privilege and the privilege against self-incrimination at sections 48(5) and 48(6). Is this section intended to simply prohibit the derivative use of the information? What is precisely being protected here? And section 55, I think that's the only... No, I'm sorry.
Yes, there's the one from...
Member Warmington also proposed to delete section 55, subsection 5, which reads as follows: for the purposes of the Defamation Act, any report made by the Commission under this Act and any fair and accurate comment thereon shall be deemed to be privileged. And his rationale is that the immunity given to members of the Commission and staff must be amended so as to remove this immunity. I don't believe the Permanent Secretaries Board had
no, I don't think you have any
comment on privilege. Right. And just for clarity and for those listening, Chair, Section 55 begins Part 7 of the Act, Privilege and Confidentiality. And it says at 1, subject to subsection 2, no proceedings shall be brought against any person in respect of any action carried out by the person in the performance of his functions under this Act. However, the privilege is limited in that it does not apply to proceedings on the grounds of gross negligence, malice, or the use of unreasonable force. Subsection 3 speaks to no proceeding whatsoever shall lie against the Commission, except as specified under subsection 2, that's the part about gross negligence and malice. No proceedings whatsoever shall lie against the Commission or any person authorized by the Commission for anything done, reported, or said by the Commission in the performance of its functions under this Act. And at 4, anything said or information supplied or any document or thing produced by any person for the purpose or in the course of any investigation by or proceedings before the Commission under this Act shall be absolutely privileged in the same manner as if the investigation or proceedings were proceedings in a court of law. And subsection 5, for the purposes of the Defamation Act, any report made by the Commission under this act, and any fair and accurate comment thereon shall be deemed to be privileged. So Chairman, Norman Manley wants a definition of privilege. I think well, for me personally, Chair, I would seek guidance from the.
No.
I don't.
No.
To my knowledge, privilege is a term of art in law, and there's a lot of
we move on
case
to the
law
next
on
the next position.
The next position, Chair, is that the immunity.
That's right.
From suit for defamation be removed from the commission. That's at subsection 5. I'm afraid, Chair, that I also don't think I could agree with this one. I think if we put our bodies under threat of suits for defamation, that is definitely one way of completely gagging them.
They wouldn't serve.
And so, but the other thing is, we are making
56.
such sweeping amendments to this act that I think we are putting in some of the safeguards to ensure that there is not reckless commentary and so on that's happening here. And as I say that, Chair, yes, SG had acknowledged that she would review her files.
56?
56. 56 is a confidentiality regarding information, and the Integrity Commission has recommended that, having reviewed the reference section of the Act, it is of the opinion that due consideration should be given to amending Section 56(1) with a view to achieving a proportionate balance between matters which are deemed secret and confidential and should rightfully be treated as such, and the broader objectives of openness and transparency, which are crucial to anti-corruption efforts and are deemed to be international best practices. The rationale for this is that the intention of the recommendation is to allow the Commission sufficient latitude to execute its mandate while also responsibly facilitating transparency in key operational areas, which will complement the work of the Commission and build overall public confidence in the anti-corruption efforts. In the alternative, the current provision should be deleted. That's the Integrity Commission's remarks. We have two more, Chair.
I know you do, but the SC wants to make a comment.
I just wanted clarification. It appears on that same point. I understand the alternative, which is to delete the provision, but what's the other option? What is the actual amendment they want?
For be able to comment.
Yes.
Let me express my concern, and how we word it is important. The provision as is prevents the routine publication of contracts that the government of Jamaica enters into, because that is considered to be confidential, right? Now, there may be, now in my view, that is not consistent with principles of good governance and transparency. Now, there may be many other matters which come to the Integrity Commission, which in my view would fall under the category of being confidential, but certainly something where a process is entered, you go through a procurement thing, you have a procurement committee, a contract is awarded, that cannot be considered to be secret and confidential. So in my view, the amendment must take account of something like that, which in my view should be in the public domain, but there may be other issues which rightfully need to be protected based on information that comes to the Integrity Commission. So I'm using one particular example of contracts. There may be others, but that, in my view, is injurious to good governance to retain that. Am I saying that we should delete the clause entirely? No, because I do believe other information may, in fact, rightfully be considered secret and confidential.
Interesting, interesting position, yes.
Chairman, can I ask a question in relation to contracts? All government contracts, or the vast majority of government contracts, are subject to the public procurement commission approval. Yes? That's a correct position? No, not sure? I'm just wondering about the rationale for the confidentiality of a government contract. If at the end of the day, I think it's what's over the threshold, Member Robinson? Is it 3 million? If all of them end up going to the Public Procurement Commission anyway, is the PBC under a duty to keep those contracts confidential?
Yes, under the Public Procurement Act, there is a secrecy provision there. I was looking at the Turks and Caicos Act. So I'd asked for clarification about what type of amendment the Integrity Commission was asking for. And I got some clarification from Member Robinson. And I'm just going to read 47.1 from Turks and Caicos Integrity Commission Act. It says, every member of the Commission and every person performing any function in the service or as an employee of the Commission shall treat all records and information relating to declarations as secret and confidential and shall not disclose or communicate the text of any record or information or declaration to any unauthorized person or to allow any unauthorized person to have access to the records, information, or declarations. So I realize that the provision we have is much wider. Mm-hmm. Right, so perhaps this is one, right, so this could be perhaps used as a guide in terms of how we narrow it, because certainly you do want to protect and treat as confidential the information contained in the statutory declarations. Mm-hmm. And it is a constitutional duty. My colleague here is reminded me of our right to privacy, and it's a constitutional obligation, as well as it's an obligation under our Data Protection Act. Mm-hmm. But as it relates to some of these other matters that we have included, it is certainly something that can be reconsidered by the committee. Yeah, because this clause is saying prescribed licenses are under confidential cover. Why would a license be under confidential cover? Yes. But my question is, the SG, and I can wait for this answer, but you're saying that the PPC is under a duty of confidentiality in relation to contracts generally? What's the extent? Mm-hmm. Because I guess I'm trying to understand the rationale in terms of government contracts not being published to the public. I certainly see the transparency principles and the need for that, just for good governance, for that to be put into the public domain. There may be other considerations with certain contracts that would preclude those. National security, right, defense matters, that kind of thing. And maybe even some you said national security, right. But what is the status now? Are they published regularly? I'm sorry, I don't. Yeah. They're not published at all? Thank you. I think I'll have to respond in a more fulsome manner. You're not supposed to use the word fulsome, but in a more detailed manner in the next meeting. Mm-hmm. But just remember that under the Public Procurement Act, because you have a procurement process, you'd have to be very careful about what is published and at what time, because it can create a problem. So under the Public Procurement Act, for instance, when letters go out, it's very detailed about when you publish information, but information is published and allowed to be published under this act. it's a timing issue because you don't want to.
Because of the competitive nature of the process.
Exactly.
No, it would have to be at the
Right.
conclusion of the process.
And well, some things, well, you do have different stages of the procurement process, so some things can be published along the way. So for instance, when they complete one step, there are times when you can inform parties if they are no longer included in the process, and they can get certain types of information, but it's outlined here. But I was just looking to see if they actually have a secrecy provision and look to see how it was worded. I can't find it yet, so I'll continue looking.
But it's also not as simple as it's good for governance, so publish the contracts. Because at the end of the day, the question to Member Robertson might be, is that something for the Integrity Commission Act, or is that something for the Public Procurement Act? Are we in the right act for that duty?
Well, it arose because formally under the OCG, that office would, on a quarterly basis, on its website, put those contracts that have been concluded in the public domain. And that was the single repository, as far as I knew, for all of that publication. Now, whether it should sit with the IC or the public procurement body, I can't opine specifically on that. What I'm very strongly in support of is for that disclosure to be made, because right now, I mean, I can tell you from my perspective, when we get in Parliament cabinet submissions, that's when we see contracts that have been approved and signed off by the cabinet. But unless they're made public with a sign-in, really you have no idea what those are. And that certainly can't be in the public's interest at this point in time. But I do think it has to be tweaked. It must preserve privacy and confidentiality of statutory declarations, investigations, information which comes into the Commission in the advancement of an investigation. Those things must remain protected. But as I said, in the case of contracts which would have gone through a very detailed process and a company awarded, the public has a right to know how those funds are being used.
So I've found the confidentiality provision in the Public Procurement Act, and it has a scheme where even if documents could have been disclosed, you don't have to disclose them if it would be contrary to law, impede law enforcement, prejudice the legitimate commercial interests of a supplier, bidder, or contractor, or impede fair competition. And of course, information relating to the examination, evaluation of bids, other than the summary of the evaluation of bids, are not to be disclosed, but the summary can be disclosed at a certain point. So it does allow for the disclosure of documents. So I'm thinking, as it relates to the provision in the Integrity Commission Act that speaks about government contracts being confidential, I'm not sure you need to address it in the Integrity Commission Act, because it would fall under the purview of the Public Procurement Act, and I don't think you need to go above and beyond what is in the Public Procurement Act. So I'm already thinking that that could be deleted from the Integrity Commission Act, because government contracts are dealt with in the Public Procurement Act.
Yes. I think we can move on, because that guidance from SG is absolutely spot on. So, members, we would now truncate at the point of, I think 56, 57 is an easy one. Yes? No, we still have a few more. But can we just do 57? The others are pretty straightforward. Can we do 57?
Sure. 57, Chair. Did that have any
Yeah,
comments?
it's the one from Norman Manley.
Okay, that's the one from Norman
Norman
Manley.
Manley,
It's
yes.
about the oath taken by the commissioners and the staff of the commission. And
straightforward,
Norman
isn't
Manley
it?
says, in section 57, this section should be amended to permit the commissioners, the executive director, and the commission staff to make an affirmation of secrecy if the object is swearing by oath in accordance with an affirmation of secrecy if they object to swearing by oath, I think is what that
Yes,
should
yeah.
be, in
That's-
accordance with Section 6 of the Oaths Act. Consequential amendments should be made in the first schedule if this recommendation is adopted.
Yeah,
I don't think it needs to be written,
Not a
though. The
problem.
Oaths Act
Move
exists, and that's
Okay.
it, yeah. I don't think it's
And
required.
then 61.
Chair,
SG? I'm sorry.
The PS board had 2 comments on
Oh.
56.
56? Oh, I'm so sorry. Forgive me, Chair. PS Board on 56. In section 56.2, I'm sorry, confidentiality regarding information. In relation to section 56.3 and all other sections relating to fines, it is recommended that a review of all fines referred to in the Act be conducted. It is also recommended that close attention be given to the fine and penalty associated with sections 43.2 and sections 56.3. And 56.3 would be the disclosure of the confidential information. They further ask Chair, in section 56.2, we propose a non-disclosure agreement or post-employment restriction for staff of the Integrity Commission. Post-employment. I don't think so, because there's a duty of confidentiality, which persists.
Yes.
It persists at 50,
Sorry, SG?
57.
So there is we do have what is probably now a standard provision in our secrecy clauses that includes that, but I can check back my files, but I think it was rejected when we were at joint select for this bill. I don't think it was agreed. So this is why it's not there, because we usually have a form of words in our secrecy provision that deals with not revealing the information even after you've left the employment
No, it's
of
there.
the entity.
It's there at 57B, isn't it? Commissioner, executive director, directors, and every member of the staff of the commission shall, subject to section 56,
Oh, it does have
maintain.
it.
Yeah?
Okay, so it does have
That's
it.
it, okay.
Yes.
So I'm not sure that you would need, so I don't know then why this recommendation is made then.
57.
So it's already there.
It's there.
It's answered. Yeah, it's answered.
Very well. Okay, so we just dealt with 57, because that one we accepted, that was easy. And then 61, 62, 63, 64, 65 will go. Then we go to the second schedule. Yes.
Chairman,
Did we agree on 60?
60?
60, Integrity
There were-
Commission,
there was-
regulation ought to have been blah, blah. Go ahead. 60.
60, the Integrity Commission says, section 60, subsection 1, provides that the commission may make regulations subject to affirmative resolution in both houses of parliament. It is the considered view of the commission that regulations ought to have been prepared before the act came into operation. The commission is of the view that these regulations should be made subject to negative rather than affirmative resolution. The process by way of negative resolution will take a shorter period for them to be passed in Parliament. That's not true.
Yeah.
It's the same process. It's just,
Okay, we'll move on.
yeah.
That's another-
And what regulations would they want?
No, it's all right.
That's it.
Okay,
We currently don't have regulations at the moment. Right.
so you have 63?
So 63.
As one, Mr. Warmington says, recommended it is being proposed
Hold on,
to
Chair.
delete sections.
Did you jump over? Oh, this is just the transitional provisions. Vesting of property.
Savings of action
Sorry.
and investigation.
Right. So
What does that
63.
provision say? What does it say in the act?
Savings of action and investigation. It's a savings clause for the work that would have been going on before the Integrity Commission was formed. So the investigations and the actions being taken by the Contractor General and the Corruption Prevention Commission.
Activities prior to 2017?
Prior to 2017, yes, Chair.
Yeah, well, I agree.
So
That section should be
63
deleted,
says, there's only one comment, and that's
That it should be
Member
deleted.
Warmington, that it should be deleted.
Yes.
No, not all of it. 63(2), which reads, the commission established under this act may commence or assume any investigation, swear any information, or commence any or conduct any prosecution in respect of an offense committed or alleged to be committed before the appointed day, meaning of this act, under a provision of either of the amended acts that has been amended or repealed by this act, or under the repealed act, and each such amended or repealed provision, and the repealed act shall be deemed to remain in full force and effect for the purposes of any such investigation, information, and prosecution as it had been immediately before the appointed day. That's the, and B says, or the commission established under this act may continue or do any acting or investigation which was pending before the appointed day.
Yes.
What I'm saying here is that 63(2) asks it to be deleted as spent by passage of time, which is over 8 years. This was in place to allow them to look at issues before the establishment of the act. And if there are issues that you haven't found in 8 years, I don't see the relevance of it now. So I'm saying in the passage of time, this issue of going back 8 years doesn't make sense. It has outlived its usefulness, and I ask for it to be deleted.
Comments, members? Comments, members? Okay, accepted.
No.
Well, we haven't had any negative position on it, or
I don't have any difficulty with that rationale, Chair. I would want to know from the Integrity Commission if there are matters still lingering from pre-2017. And I have a vague recollection of us having that query about that when they were before us, but I'm not really remembering the answer at the moment.
it
would not affect any investigation ongoing at this time, you know. If they have investigation going by that time, but I'm saying after 7 years, after 8 years, and you haven't found any issues, new issues, it doesn't make sense because any new issues that are new, you would have had them dealt with or found them within the 8 years. So I'm saying by over time.
Yeah.
This issue, the pass of time, this is spent.
Yeah, I don't have a difficulty with Member Warmington's proposal because remember too that this is referring to any matters for which it is the repealed act or the repealed provisions that would apply. It would not be this Integrity Commission Act. And so I would want to think, subject to the Integrity Commission saying anything different, that all those matters have been done and dusted.
Essie?
So, thank you, Chair. There are two things that are addressed under 63(2). One is that they can continue to do any acting or investigation which was pending. And I think the committee would need to ask the Integrity Commission if they have anything pending prior to the new act being brought into force. But there is another thing that is, and that's in A. It says that if there was an investigation already ongoing, or they could commence a new one, but if it was for if it was for a period before 2017, you have to use the old law. You wouldn't use this act.
Right.
Right. So if you repeal this section, you're now going to be removing that provision. And in any case, that's a provision that's in the Interpretation Act. We actually didn't need to put it here because it's in the Interpretation Act. So even if you remove it from here, it's going to still operate, because under the Interpretation Act, Section 25 deals with the effect of a repeal, and it allows for persons' rights, any right that you had prior, you still would maintain that right, as well as it says it wouldn't affect any investigation, legal proceedings, remedy, and any such investigation that is instituted, continued, or enforced would be done under the repeal
previous
act.
Right.
Right.
But SG, the investigation, I think what might, and I won't speak for you, Member Warmington, correct me if I'm wrong, but the provision that allows the Commission to commence an investigation I need to look at the Interpretation Act. I need to look at the Interpretation Act because is that into perpetuity? Does that mean that the Integrity Commission in 2040 could commence an investigation on something that happened in 2015? But that's I think what the concern is. How long? What's the lifespan of that provision in law? Chair, I'm looking at the time. Can we also push this to you for some review at the next meeting? Say again?
Sorry. Oh. Yes, but I'm saying this is basically saying what the Interpretation Act says. Normally what would happen is over the passage of time, you wouldn't expect that you would have, it is a power that is given under the Interpretation Act.
And I'm asking SG, is the power so vast that in 2030, 2035, the Integrity Commission could commence an investigation on a matter that would have happened prior to this act coming into view? That's the question I was asking.
Right, but practically I cannot see how that would happen because evidence would definitely, but they have that right.
Well, that's the question I asked because I have heard members speaking about being asked in their statutory declaration for information about things that they had in accounts from the 70s and things like that. I have heard that.
Would not
it
fall.
doesn't.
But what I'm saying is it would now fall under the process of the repealed act. So you wouldn't be using the process of the new act to deal with those matters, or they shouldn't.
But they do.
Chairman, the SG mentioned the issue of opening new investigation. This does not prevent them from opening new investigation. I'm saying that this time has spent, it has spent its usefulness. Why would you, if in 8 years there are issues then, you didn't find it in 8 years, why are you going to find it in 30 years? If you don't find it in 8, it means after 8 years there's nothing. I'm saying this was put there to carry on investigation that the other bodies were doing. So after 8 years, it doesn't serve a purpose now. So you cannot have it going on in perpetuity. So I'm saying it doesn't serve a purpose. You delete it. It also serve its usefulness.
Okay. I'm seeing here a slight difference in terms of the views on this side and that of the SC. No?
No, it's not.
No. Okay.
Chairman, I think what SG is saying is it is the law.
It is the law.
It is the law.
So it shouldn't be?
Whether it's here or not, it's what
So
exists
it doesn't matter
in law.
where it is? So are we accepting to delete, or are we saying it
No,
remains?
we can't, because what will happen is if we delete, then we will cause those matters to come
Point
under
taken.
this new act instead
Point
of the
taken.
repealed
I just wanted
act.
that clarity. Okay.
Yeah.
So it's, no. Okay, thanks.
But Chair, this is one of those questions too that I would wish to ask the Integrity Commission, whether or not there are matters still pending that they have not commenced the investigation that were matters carrying over from the last framework.
Okay. So we will send a note in that regard.
So just a quick point. If the committee is of the view, though, that they really don't want this to apply, you would have to do more than just delete it from here. You would also have to say that Section 25 of the Interpretation Act will not apply.
Right, we understand. And I think that is why we concluded that we would leave this one alone. And yes.
No, we're not concluding that, Chair. I think we're asking for particulars from the Integrity Commission as to what is the reality.
But given the guidance we get, that this one is consequent on a number of other acts, which would then have to be repealed or
no, I don't think that's what SG has said. SG has said that if we wish to remove it, we would have to put in a provision that says that the existing provision in the Interpretation Act does not apply, because that provision exists, which provides for the same thing that this would provide for. So even if you delete this, you have to say Interpretation Act doesn't apply. But I have a difficulty and a caution with that, Chair, because I would not want us to be in a position where there are matters pending that the Integrity Commission is looking at or has not yet begun, and we are now putting in a provision to prevent them from investigating those matters. So I think it requires a request of the Integrity Commission to just provide us with some information. And I know Mr. Beresford has done that before, where he has sent us numbers of complaints and so on. He could so indicate to us if we would write to them.
Okay. If I then rule that a letter be sent to the IC to provide this information as is requested. And that will guide us in our next meeting so that we can, in fact, complete the matrix.
Yes, Chair.
I want to thank the members. Member Warmington, we are after
I know that there are recommendations that I made that are not included in this. I'm going to write to the committee clerk.
Which?
I'm going to write to the committee clerk.
We're not finished, remember?
You're asking for adjournment, for example.
Yes, for today. But the
that's something I'm going to write to them.
The matrix is incomplete.
No, so I'm saying I'm going to write to them as to those recommendations I don't find in the matrix for the next meeting.
Oh, that are not in the matrix?
Yeah.
Okay, very well.
Yes,
very
yes.
well. Okay, members, any other business?
No, Chair.
There being no other business, this meeting is adjourned until Tuesday.
February 18th.
No, well, a date to be fixed, I will tell you, because I believe we may have to make some adjustments in order to complete the work within the time that I've indicated. We may have to meet next week. It's a difficult week, we know, because we have the prorogation of Parliament and then the throne speech and so on. But we'll have to find some time next week to just finish this matrix so that the next 2 weeks can be spent reviewing, tidying up, and preparing for the report to go to Parliament. And I know proper guidance will then be given to our technical team to go and to do the drafting that is necessary. So it does require a little bit more rigor team, and also we need to make the time available in the next 2 weeks. Yes.
Could I request also from the committee section a list of the submissions that have been made to this committee? I find that things are kind of all over the place in the emails, and I note in my file I didn't have some submissions, some of the members didn't have it. I just want to ensure that all of the submissions that were sent, I can reconcile and ensure that I have copies
Yes.
of all of them.
You know, it's funny, I have a big file like this. Exactly, which has all the submissions and things
But
from
and yet I
everybody
didn't find the
that you keep.
JFJ submission.
All right. Well, Mr. Nash, poor Mr. Nash.
It's just a list with dates.
It's Ms.
It should be-
Beckford who will have to do that.
It should be
because-
something that the committee has easily.
Yeah. All right. So very well, member. We will see to that. So at the next meeting, hopefully, you will have a compendium of all those proposals, submissions that have been made by the various bodies that visited us during the period of discussions. The motion is on the floor. Moved by Member Robinson, seconded by Member Warmington. This meeting is adjourned.
It must stop.